Hello. It is. Good morning. I know, so I always say good morning no matter what time of day it is. So, so did your grandmother ever used to say things like my grandmother used to say if you did not speak to her, um, the first time you saw her, she would say, "I didn't sleep with you last night." Like, where's your home training? Um, anyway, hello, hello, rude. Well, right. Who are you and why are you here, my friend? Hi, my name is Jill Bates Moore. I am the other half of Dahlia Law Group, and Dahlia Law Group is a law firm in Oakland, California that Alicia and I run, and we practice in legacy and estate planning, probate litigation, and things that are related to that. Our our goal in this work is to make it accessible, to make it make sense, and to just sort of remove some of the layers of stuffiness and barriers to people, regular everyday folks, getting the information that they need to care well for themselves and their legacies. Um, Taking care of yourself and planning well for yourself is a legacy issue, and estate planning is among the tools that we use to help with that. So, we have some folks here with us. My sister is here. Hi, Danielle. Shauna's here. Hi, Shauna. Um, let's see. How you doing? Ooh, interesting. Excellent. 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 That podcast that Alicia is talking about is the Stitch Please podcast. That's the title of it. And it is produced by Black Women Stitch. You can find that wherever you get podcasts. Apple, Stitcher, Spotify. It's on all the platforms. I am overall fine. And I find myself wondering how in the world it got to be Wednesday already. Like, just popped up. It's Wednesday halfway through August. What is that? So, well, not quite halfway through. Believe me, I do not want to rush us. So just having this weird relationship with time right now, but all is well. All is well. As you said, we are getting into, well, first of all, wait, whoa. Yesterday, there was a pretty major national, international, global announcement in that one, Kamala Harris was appointed by Joe Biden to be his running mate as he seeks the U.S. presidency. And the idea of the first Black woman, somebody who looks like me, is on a vice presidential ticket. I mean, Shirley Chisholm, of course that makes me immediately think of Shirley Chisholm, who was the first Black woman in Congress and the first Black woman to seek the U.S. presidency. And I'm just floored and I just feel so many feelings about that. That representation is huge. Now listen, for whoever is watching, come with your comments, come with your questions. This is a forum for that. I am Black. I don't bury the lead on that. It is one of my favorite things about myself. And so the fact that I and we talk about Black things in this work and on this platform will come as a surprise to no one. The politics of it all, politics is party politics is a dirty game, and dirty in the sense that it is messy and muddy and there is all of so much in it. I do not believe that there is a perfect politician, and that is not what I'm talking about. I am talking about this Black woman who is on the ticket, or for the presumptive nominee. I guess that hasn't officially happened yet, but for the vice presidency of the United States. It is huge, and it is happening in my lifetime. I will argue with credible support that that this is way past due, but the fact that but I'm also not even talking about that. Like, it is happening. This is, whoo! It is something. And so that is also part of how I am doing today. So if I know you have your critiques of Kamala Harris, you have your critiques of Joe Biden, people have all of their critiques of all of the politics and all of the things. Bring them. You should. That's an important part of the work. And this is happening. Did I just make that sound that got what's his function booted from presidential politics? Who was the guy? Do you know who I'm talking about? Huh? Right? Didn't he just? Yes. Didn't he make some strange sound at a debate or a rally or something, and then you like never heard from him again? What? And then you never heard from him in presidential politics again. Oh goodness. Anyway, so that's that I just couldn't let the the recorded moment pass without acknowledging that huge, wonderful wow wow of a thing. It just I couldn't let the moment pass without that. So I know we're here to talk about other and different things. Um, mm, absolutely. I think that's a really important point. Hold on a second because I'm getting a message that there is no sound. Can you double check and just make sure? And specifically, I'm getting a message that uh, that viewers cannot hear you. I can hear you just fine, which makes this all the more confusing. Can you check that? Thanks, Tony, for letting us know. Hey Danielle, can you let us know if you could hear Alicia before? Oh, the grannies. It's like every single time we do this, we mess up some settings. Sorry, y'all. Okay, Alicia, since the sound issue is on your end, you should. Can you give us some sound so that people can see if they can hear you? Folks, this is part of what it means to be live. Okay, I just heard that. Did is Alicia back for you all? I'm just waiting for some more feedback to see if other people can hear you. I can hear you fine. Tony, will you let us know if you can hear Alicia? Nope, Danielle is saying she cannot hear you. No. Hold on. Okay, let's try this. Let's try that. Let me see
How's that?
if I
Can you
just
hear me
fixed it.
now? I feel like I'm in that commercial for, was it Verizon?
You're right. Those old commercials. Okay,
The
something
com
said muted on the soundboard end, so I just unmuted whatever that was, and hopefully that fixed it.
Here's hoping.
Yay! We
Can
got a
you hear me
yes.
now?
We got a yes.
You muted me.
Danielle says she can hear you. So
You
okay,
muted me on the soundboard.
no, I didn't. I hope I didn't. Oh gosh, this is. Can we do an outtakes? Can we do an outtakes series for the?
That's
I
the
mean,
whole
seriously,
series.
um, how is that even a thing? My mute button management is trash. It needs to be burned with fire. I don't even understand how somebody as smart as I am is continuously flummoxed by the mute button. Okay. Here's
They
what I
keep me
propose we
humble.
do. I propose that since we are, oh my goodness, I do not want to waste people's time. Since we are 15, 16 minutes in to this broadcast at this, this point, here's what I propose we do. For those of us who will introduce ourselves really, really briefly, and please repeat what you said about the legacy issue, or if you want me to summarize it, I'll do it. But let's do that in case there's anybody who's joining us now. I think somebody did leave. They're like, I can't hear you. What's going on? Um, go ahead.
They ain't talking about nothing. So welcome back. I am Alicia Holland. I am one half of Dahlia Law Group.
Go ahead. Go ahead with your and give us your summary of the legacy issue. I'll come on after.
Oh, okay. It's like, who is you? But I will continue.
Yeah, we don't have
So
time
we
for that today. We're like literally almost 20 minutes in at this point, and I don't know what the sound issues were. So
So, what we are talking about today is the continuation of legacy. So, in the conversations that we've had up to this point, we've been talking about some of the tools around your personal care decisions. So, advanced healthcare directives, power of attorney, HIPAA authorizations, nominations of conservator and guardian. And those were all about making sure that the tools are in place so that you are well taken care of during your lifetime as it's needed if support is needed around your care. Now we are about to turn the corner and start talking about legacy. And so before um, we were talking and we had our little sound thing, I think since you could hear Jill, you heard her talk about just kind of the historic moment of the day, of yesterday, in that Senator Kamala Harris was selected as the presumptive nominee for the vice presidential ticket for the presidential election that we have coming here this year. And she was saying that she's thinking about Shirley Chisholm and all of the foremothers and forefathers that went before her to come to this moment. And Jill was commenting that that is off topic. And my point is that it's not off topic at all, that is legacy. So when we think about Shirley Chisholm and John Lewis and Reverend C.T. Vivian and all of the work that they did, it was their legacy that gets us to a moment like yesterday. And so, as we turn the corner in each of our individual lives in this conversation series, that it takes us right to what we are about to start talking about, which are wills and revocable living trust and what those things are, because that gets to be our own individual way of preserving and protecting the legacy that we build within our lifetimes to make sure that it too can be well cared for the generations that come after us.
Yeah, I think that was a really important point, and not to be misunderstood. I don't think that that it's off topic. That Senator Harris's nomination or appointment is off topic, but rather they I think I was just thinking about wills and trusts for today, so that specific topic. But I really appreciate I really appreciate your sort of sort of keeping the thread of legacy in the forefront of our minds, right? Because wills and trusts is about stuff. Okay, so spoiler alert, we're talking about property, assets, that sort of thing. But I think it is easy to confuse those things with legacy. Things are not legacy, not alone, not in and of themselves. And so we're not starting a conversation about legacy today. We are continuing a conversation about legacy. This live stream is called Legacy because it's called Legacy Live Stream because that is what we do here. And we practice in legacy and estate planning. Alicia and I do in our work because legacy is its own thing, right? That is it is the stories of our lives. It is the ways that we make, right? It is the continuation of is the continuation of a path laid by people who came before us, who contribute with us in community and the things that we leave for someone else to sort of pick up that thread and continue it on. Estate planning speaks to some of the tools that we use in that legacy work. And so I really appreciate you, Alicia, for just keeping that top of mind, because you are absolutely right. Senator Kamala Harris running on the Democratic ticket for vice president of these United States is absolutely a legacy issue. So now that the sound is fixed, we got that all
No
right.
toque nada.
Oh, look at us. Oh, goodness. Okay, so don't worry about time, everybody. We will absolutely still get you out of here on time today. Today's conversation is sort of a brief flyover of what wills are and what trusts are. This is intended to be a basic overview of these two particular tools, because in the coming weeks we will actually be talking about them more specifically. We'll take each in turn and give them their own attention. So don't worry that we don't get into the nitty gritty, into the granular details today. We will absolutely be doing that. So, what is a will, Holland?
Me?
Yes.
So, what a will is it is a document that you can create where you use this document to express your wishes for what you would want to happen with your property when you die. So, you are going to, in your will, be picking the people that will have jobs in the will and laying out what you want to happen to the stuff. And so you've seen it on television and movies. The very formal, we're having the reading of the will, or sometimes you'll hear it called the last will and testament. And so it's I bequeath this to, so I'm giving my Mickey Mouse collection to this person, and I'm giving my this to that person. and to this person I leave $1, or I leave them nothing. All of that sort of stuff. All of those things are a will. So the reason it sounds like it can be a very simple document and process, the reason that we talk about it and we talk about it in this way is because in order for that will to be recognized as a valid instrument, there are some technical things that need to happen correctly to make sure that the things that you have put in that document, that those decisions and instructions can be respected.
Yeah, a will is one of the. I mean, it's a really old type of legal technology. Yeah, that allows you to pass your stuff on from you to other people. You can also use a will to nominate guardians of your children. A trust. Well, first of all, a will usually involves a court process called probate, and we will talk about that more when we talk more specifically about wills. I bring it up now because a trust can accomplish some very similar things, right? But without the court process, in most instances, a trust is a contract. It is a contract with yourself to for certain decisions and for certain distributions. That's what we call it when we are giving something to someone, for certain distributions. This is the thing that people think about and talk about when when something is held in trust, a property is held in trust, or when somebody is a trust fund baby. I don't know if that's even a thing that people say anymore, but funds that are held in trust for the benefit of somebody else is what that term refers to. There are multiple different types of trusts. Okay, this is sort of a big landscape, and so I want to focus our attention on what we will be exploring in this series. The specific type of trust that we will be talking about is a revocable living trust. A revocable living trust. Revocable because somebody can revoke it. Living because you make it while you are alive, and trust because it's trust, right? It's also called a probate avoidance trust, and that speaks to that idea that I was talking about. That a trust can accomplish a lot of the same objectives as a will without having to go to court. Okay, without having to go through that process, without having to go through that probate process. Sorry, I got a little distracted because Lisa is here. Hi, Lisa. And she's commenting that she wishes she could say she was a trust fund baby. She was born smart and good looking instead. I agree 100%.
100%.
Thanks for being here. Let's talk a little bit about what the technical differences are, right? We've already talked about some of the similarities, but there are some other similarities, so maybe we should talk about those and then talk about some of the differences. What do you think?
Sure, let's do it.
All right, go ahead.
Okay, I am the we.
No, you're just going first. So. I won't leave you hanging. I've just been talking for a while, so I thought it'd be good for balance.
I got it.
Shady.
So we just talked about in both wills and trust that the ultimate thing that we are doing in each of these instruments is we are giving instructions about distributions. We are making instruction for the things that we want to give to particular people, what we want to have happen with them. So that naturally leads to the question of, well, what's the difference between the two? How do I know which one I should be getting? And so there are some commonalities in the two. So one commonality is that for both of them, you have to have mental capacity to establish it. And so that mental capacity is going to be, you need to understand the basics of what this thing is and what the impact is of what you are doing in this document. So in some states, the amount that you have to have, amount of mental capacity you have to have is actually different between the two instruments. So with a trust, like Joe was just saying, because it is a contract, that can require a different level of mental capacity to enter into a contract versus a will where you are just making documentation of the things that you may want to give away and how you want that to go. So another commonality in the two is that they are, I mentioned that on the will side, where you are putting somebody in charge, you're going to also do that on the trust side. So you're giving a job to somebody to do these instructions that you're laying out. So we're giving somebody a job in both of them, and we are making instruction for what we want to happen to our things in each of them. That is where then our commonality kind of diverges in the two paths.
Right. Because then what happens with a will, so switching to those differences, a will usually requires that court process called probate, and we'll talk a little bit more about that in this episode. But honestly, we'll get into more of the specifics of that in later episodes. A will usually requires that court probate process. A will does not typically have any relevance until you're dead. You make it while you are alive for the purpose of deciding what happens after your death. It is also, it's also not private, right? And for some people, that can be more or less important. Whereas with a trust, you create it and set up trigger events that will allow whoever you've put in place, whoever you've appointed as trustee. That is the role that is sort of the executive manager of the trust, the role that is responsible for making sure that all the things get done. You set up trigger events that empower your trustee to act once that trigger event happens. So for example, a trigger event might be your death, right? When I pass away, make sure that, my son gets the house, or my daughter gets the house. That trigger event might also be, and here's a key difference, incapacity. Remember when I said a will is only relevant when you pass away. A trust has a little bit more flexibility than that, and you can make certain decisions and create certain powers if you are incapacitated. And so when I say incapacitated, you might naturally think about some of the tools that we talked about earlier in the series that were useful for incapacity planning, right? The Advanced Healthcare Directive, the power of attorney, that sort of thing. Well, a trust has the capacity. Aha, see what I did there? I'm such a cornball. All right, sorry, y'all.
You're not sorry.
You're right. So a trust can, be a powerful tool for incapacity planning as well, because it can be used while you are alive. All right. What is the consequence?
Do I have to have one?
I'm sorry?
Do I have to have a will or a trust?
Well, I was going to ask that very question, or something related. What's the consequence for not having a will or a trust or something in one of those tools, right? To decide, to articulate what will happen to your stuff and things in the event of your death.
A flash of great minds thinking alike. So, so what happens if you don't have either a will or a trust to say, what you want to happen with your things, then it frankly means the state decides. So within your state, every state has one. They have some code sections within the probate code. A word that you might hear is something that's called intestacy or intestate, which means that a person has died without a will. And so, in those intestacy statutes, which is a mouthful of word to say, but it's a set of code sections, it actually says if we have a person who has died without a paper to say what needs to happen, so no will, no trust, then this is the hierarchy of what should happen with the stuff. And this is the hierarchy of who we think should be taking care of the children.
Mm-hmm.
And so that involves that court process that Jill was talking about with probate, where a judge is going to make a ruling about those things of the who gets what and who is responsible for taking care of the children. And so the reason we talk about these papers is because you might not agree with what the code section says and what the judge is likely going to rule about what happens with these things. And
Right.
so that's where the papers come in.
Yeah, absolutely. It's about, I mean, I was just thinking about this idea of legacy. Sorry, I stopped myself. That was probably a little weird, but I just had this flash of an idea that legacy is, we talked about legacy being about the stuff and the stories of our lives, right? And that will naturally include some things that you don't have any control over, right? There are things that happen in life that sometimes you just don't get a say. But a very important part of your legacy is the things that you get to decide for yourself, right? And so this idea that Alicia was just explaining was that if you don't say what happens, then somebody else will say what happens. And it may not be consistent with your values. It may not be consistent with your desires. It might be. That might be just fine, right? But either way, it is going to be a part of your legacy. That's the idea that just popped in my head, right? And so I looked like stop motion for a second. Sorry. Okay, so we are. We also thought it would be a good idea to talk about what type of considerations we might make for in deciding why or when we would use one tool versus another, or frankly, when you would use one tool versus another, because either these decisions are so highly personal and there really is no wrong answer unless there is a unless there is a tool. My goodness. Folks in these comments. Sorry. I'll share it with you in a second. There is no wrong answer unless the tool that you use, whether it is a will, whether it is a trust, whether it is the legal process that already exists without a will or a trust, the only wrong answer is the one that does not fit with your values, right? Is the one that does not fit with what you want to happen. Lisa Lisa is saying that she's shouting, testes, I need to get this together. If my sons are informed that something is in testes, they will fall out laughing until they realize that I have totally screwed up and it's not a joke. Yes, the word is Lisa. The word Alicia was talking about was intestacy. Intestacy.
Goodness me.
Okay. So I am going to give you a super summary definition of intestacy. It's the process of transferring property without a will or a trust. Okay. That's intestacy or intestate transfer. So, considerations for why someone would use a will as their tool or a trust as their tool or nothing. I think that those considerations include ease, they include privacy, they can be considerations around the expense of both putting the tool together but also using it, right? So it might be free to not have a plan at all, right? And to just go through that intestate transfer process when you die without a will or a trust in place. But it could be very expensive. To
In the
the
long
procedure
run.
itself could be very expensive to your estate, and also time is a consideration because of course the timelines for when you get to act and do something yourself right away is different than when you have to depend on another entity like a court in order to make it happen for you. Are there are there some other considerations that you want to talk about, Alicia?
No, I think those are really kind of the high level categories for the considerations for how you have this in play. So, breaking it down and thinking of some of the more specifics of it. So, thinking particularly around that privacy, expense, and time piece of it.
Mm-hmm.
When we are in the land of a will, that court process that Jill's been mentioning called probate is really coming into play with those three factors in particular. Because the court probate process is one that, like she said, it's public. So when you file the documents to say this person has died and their will now needs to be what is called probated, so run through this court process that is happening, then that is going to be a public process. Anybody has access to those filings. Those filings are going to include all of the assets as well as the debts that are a part of that estate. All of that information is public as well. It is a lengthy process. So one of the things that always happens, there are some lawyer shows that I love on television, and it always is a marvel to me when somebody walks into the lawyer's office and says, we got this problem, we need to deal with it. And then they are in court that afternoon talking to the
Never.
judge and
Not a
getting a
chance.
ruling about it. It
Not a
amuses me
chance.
greatly because that never happens in real life.
Not in Oakland,
Even our
California.
emergency hearings take several days before you can even get a date with the court. So it is a lengthy process, partly because just the timing of the things that are happening with the court. But when you are in that process, you are subject to the code sections that apply. And there are certain things that you have to do where it might be you have to do this thing and then you have to wait a period of time, allowing people to come in and make their objections or give notices. And so that could be a period of several months before you can take any action on the next thing. So it can be a long process that you're dealing with. And then there are some real cost involved. And so with probate in particular, to give you the example, we talked about California, because we are California lawyers and our practice is situated in California. We have what are called statutory fees for probate. And so when you are going through that process, in addition to the cost that are involved with just getting into the court to go through this filing process, there are also some fees that are attached with if you have, for instance, if you have an attorney representing you, that the code section actually says what those fees are going to be. And there are other folks that have jobs that you can't get out of in that process that also get to send a bill, and all those people get to be paid first before the distributions happen. And so where Jill was mentioning that it might be free or low cost in the front end, those fees can add up greatly, because if you're in a state like California, where those fees are based on a percentage of the overall value of the estate that you're dealing with. So those are some of the big considerations that we think about when we are thinking about which one do we go with, the trust versus the will? Because that probate process and kind of some of those elements that are involved there. And once you hear those things, may say, wait a minute, I don't want my things tied up in a public way, in a long drawn out way, or in that expensive of a way. Is there a way that I can avoid that so that I can get my things to my people as quickly as possible and minimize some of the expense that's involved in that transfer? And so if you're thinking about some of those things, then that might shift you in the land of thinking about a trust, because that is a thing that can be done privately, because in the papers we have laid out the things that need to happen and given the people the power to actually be able to do it. That's one of the other things on that probate side is in the will we said who we want to do the job and where we want the things to go, but they don't have the power to do it without the court order that we are getting on that probate side. On the
Right.
trust, in that contract that we are creating, we are setting up the power part of it as well so that it can all be handled privately.
Got it. Yeah,
You
I was
can
gonna
say
say
something?
before we move too far into the trust, I wanted to just chime in and say that it's helpful to think of these considerations as right now as just data. Okay. Some of these tools have a reputation of being bad, right? Probate, for example, has has a reputation of being bad. Like you definitely want to stay out of probate court. You don't ever want to go to court. We hear people say that all the time. And it as my grandmother used to say, it ain't necessarily so. Okay, one of the great things about a court process is notice. Like Alicia was talking about when she was talking about the time that it can take. Sometimes the reason it takes the process takes the time that it does is because people are entitled to notice, right? To know what's going on and to have an opportunity to be heard. Notice and an opportunity to be heard. That is one definition of a type of due process, right? So it is a way of allowing people into the conversation so that if they have something to say about it, then they get to say it, right? And then in the end of all of that, there will be certainty in the form of a court order. And so I just wanted to offer that right now what we're giving is sort of pure data. Really, it's just pure information, and you can decide for yourselves at the right time whether a tool is bad for you or good for you, right? Because that depends so much on your values and your situation, right? So if I am living in a highly contentious family situation and I know that my children, bless their souls, are just not going to agree with one another about what needs to happen with my assets, no matter what I have written down, right? there's just going to be some trouble in the water no matter what. Then you know what, that probate procedure that has such a bad reputation might be the very best thing because of the notice, because of the certainty, because of the supervision. So I just wanted to offer that. I didn't mean to cut you off.
No, I think that's a really important point, because I think with that, for instance, talking about probate, there's also the transparency
Mm-hmm.
of it all. So thinking about that highly contentious family situation and making the distinction of, I know my kids are going to fight about it no matter what I write on the paper, is not a reason to write nothing.
Right.
That's not what we're
Yeah.
saying. It's write it down, but it might be, I would prefer it be through the court process so that we can have somebody with some teeth that has to oversee that process and can ensure that my instructions are followed. So if they're going to be fighting anyways, let me pick who's going to be the referee.
Right.
might be what you're saying. And so then that would be a perhaps I should be looking more towards a will so that it can go through that process with that transparency instead of a trust, which is going to be handled privately. And so the way that you get that court oversight referee process ends up looking very different
Yeah.
on that side of it.
Yeah.
So these are some of those considerations where we're thinking about, because privacy might not be the overarching consideration for you,
Right.
or the expense of it may not be the overarching expense for you. It may be worth it to have it going through that transparent process.
Yeah.
Flip side, you may say the only asset that I have to pass on to these children is this house, and I would like to not have a bunch of the value tied up going through that court process. Is there a way that I can get it to them and minimize that expense? And so then you might be looking at, okay, perhaps a trust is a vehicle that I may use, because thinking about those main consideration themes that we talked about of ease, privacy, expense, and time, while a trust may have some more steps in the creation of it and how you get it accomplished, it's going to be a private administration. It is something that expense wise in the administration of it, so how we carry out those instructions, is not going to have as many expenses tied to it as the probate side did. And
Possibly.
It may not.
Yeah.
It's a lawyer thing. We can't help ourselves. We don't have a lot of things in the law, and especially in this area, where there is a hard and fast applies to everything rule. It just doesn't work that way. So it's possible that you can have cheaper expenses, but the other thing that can be in a consideration when you're thinking about the trust side is the timing aspect of it. And so there are going to be some notices that happen, but things can happen in a much swifter timetable. And they are things that your people that have the job get to have a bit more control over the timetable that you're dealing with. Whereas when you are on the other side, the will and probate side, the code sections and the court schedule are really what are going to determine the timing of it.
Absolutely.
And so you can bounce back and forth between those two. So it's just thinking about this overview of the difference between the two. So as we start getting into kind of our coming conversations, then you can be thinking about which of these things actually apply more for your personal situation.
Right. So I think that, because we love this work and this is what we do and we get excited about it, it is easy for us to start, really diving into the specifics of these things. And so I want to minimize our risk of doing that. And I want to be mindful of the time as well. So, because I'm like, yeah, I have like 3 more points that I wanted to add on, and this is not the time or place to do that. So what I think would be great to do, Alicia, right now, if your game is to just hit a recap of some of these considerations, just sort of bullet point style. I don't mind doing that. And then let's talk about homework, because there are a couple of things that you can do after today's episode. Does that work for you, or would you like to approach it differently? Okay.
Let's go.
Excellent. Okay, so both a will and a trust will help you are tools that will allow you to decide what happens to your stuff when you die. Full stop. Okay? You can create both a will and a trust during your lifetime. As between these two tools, however, only a trust is the one that you can use during your lifetime. You won't really be able to use your will until you pass away. Some considerations to be thinking about when you're thinking about which of these tools might be a good one for you are ease ease of setup, right? But also ease of use, right? Privacy, expense, and the time that it takes, both to set it up and to go through whatever process is necessary to use it. For a will, that process is likely going to be some form of court process called probate. For a trust, that process is likely to be a more private process that hopefully will not have you having to go to court. There are reasons to use both of these tools, to use either of these tools, to use no tool at all. We don't recommend that last one, but we don't frequently recommend that last one. Sometimes it actually is the right thing, but those reasons start with your values and your situation. Okay, so let's talk a little bit about homework. I have one for you, and Alicia has one for you as well. But before we turn to that, Alicia, did I miss anything on the recap?
No.
Okay. All right. My homework item for you is and I'm claiming this one because it is probably the only time I will ever tell you to do this in a legal context. Open up your Google.
Yeah, Google.
Google this phrase, quote, small estate probate limit, and put in your state. So hold on a second. I'm gonna write that down for you. Google small estate probate limit for your state. Okay? This will tell you about a particular type of probate procedure that may be available in your state. So in California, I would Google small estate probate limit California. All right. And this will tell you whether your state has what is called a summary probate procedure. So it's designed to be, I hate to use the term quick and dirty, but that's the one that's coming to mind, right? It's designed to get you in and out as quickly as possible if you have to go to court at all, because there are for some things that you might not have to do it at all. So Google that, and then if your state does have a small estate probate or a summary procedure for probate, then think about it. Think about what you own today. And, if the worst were to happen to you today, would your estate qualify for that small or summary procedure? Whatever the answer is, use it as part of your consideration, right? For whether a trust or a will, like your beginning thoughts about whether a trust or a will might be right for you. Again, we start with values first, values always first, values first and out front, and then situation. And this is sort of speaking to your situation. So that's one homework item from me. Alicia has another homework item, and then we'll turn you all loose.
So my homework item is more of a thought exercise. And what you are going to be doing is going to set up how you start making your selection between these two tools. So I want you to start thinking about the list of things that are priority for you in planning, and if there are certain instructions for what you would want to have happening with those things. And so you are not necessarily just thinking about your things that have the highest dollar value. You're thinking about the things that, as you look around and prioritize, that you would want to make sure this thing goes to this specific person. So it may be the things that have your highest dollar value. So thinking about your house, or the assets of an account, something of that nature. They may be things that have more sentimental value to you that you would want to make sure that those go to a particular person. So, your set of recipes, your set of cookbooks, your family Bible, and if you have a certain person that you would want those things to go to. And just start making notes about those things because ultimately they will end up landing within the documents that we are talking about.
Yep. So you've got your two homework items. We try to leave you with something actionable to do after every live stream, so that you are making forward progress in your planning. And believe you me, the thinking about it is an important part of the process. So don't worry. Don't worry about that. Yeah. Um, Before we head out, I just want to thank you all, as always, for being here. I want to thank you for your questions. If you have more questions, comments, concerns, or anything like that, please use this time to send them over to us. We will be happy to engage with them right here, right now. That's why we do this as a live stream, so that you can get real time answers. Uh, Also, thank you for your patience and your grace with the sound issues at the very beginning of the episode. We do take this live stream very seriously. It is one of the things that we absolutely love, that we get to do, that we are privileged to do in our practice, and we want it to be accessible and useful to you in all the ways. We will see if we can go back and figure out how to get rid of the first part of the episode where the sound issues were, so that if you come back to this stream, or if you are forwarding the recording on to someone or something like that, that they aren't stuck with that beginning part where you couldn't really hear everything that you needed to hear. So thank you for your grace. Thank you for holding space for us to show up in the fullness of our humanity, including the things that we are able to do well, and also the
Granny's
things
on the
that,
internet.
yeah, and also the things that we're not so excellent at yet. We are working on it, and we appreciate you being here with us as we do. Lisa says, thanks again for another great session. Thank you, Lisa, for being here. Alicia, where can the people find us?
So you can find us here every Wednesday on the YouTubes at 12:30 Pacific Time, 3:30 Eastern Time. In this conversation, you can also find us on Instagram at Dahlia Law Group is our Instagram handle, and Dahlia is spelled like the flower, Dahlia. You can also find us on our website, www.dahlialawgroup.com.
All right, I will put those things in the chat box, and yeah, we will look forward to seeing you all next week, 12:30 Pacific Time, 3:30 Eastern, right here, and we will continue the deep dive into trusts and wills. I don't recall off the top of my head whether we're starting with wills or we're starting with trusts, but it'll be one of them, and
Come
it'll be
back and
here.
find out.
All right, you all have a good day. Thank you again.